Now today is the 25th of October 2021. It's we're almost through October, which is historically Domestic Abuse Awareness Month, and there's one high-profile Crown or Her Majesty on the versus Penelope Jackson. Penelope Jackson is a 66-year-old lady who's facing a life in prison for murder. She's pleaded guilty for manslaughter, which in itself carries a life sentence, if proven. In mitigation, she cited that she suffered some 25 years of domestic abuse. Now, I have set up part of governmental petitions on this, but there's nothing a governmental petition can do on an existing case. It can only do things about future cases. However, fear not. I'm now going to give 3 cases now that are going to hopefully mitigate her possible life sentence to a suspended sentence. Now, I do not know who her lawyers are, so what I'm asking you to do is to share this video far and wide in the hope that her lawyers do get to see what I'm about to tell you, because this hopefully will get this get the case against her annulled. And the thing is, I'm very good at this sort of thing, because when Tommy Robinson faced his kangaroo court a few years ago, I actually wrote to his lawyers giving him case law, and they used that case law to actually get a retrial for him, although he got done at the retrial. He was a bit of an idiot in the way he did things, but that's a different story altogether. And there was one case in the case of the in the Alan Harper case, where a police officer was dragged behind the car for quite some distance and died as a result. Now, I looked at the judgment, and I found a back door for the Attorney General to ask for a more harsher sentence. I wrote to the Attorney General, and I don't know if they saw my letter, but obviously they did actually try and get a harsher sentence. That said, I think the Attorney General was incompetent in that case, but that's a different story altogether. Right, here we go. There are 3 cases that actually hopefully will give her a suspended sentence as opposed to life imprisonment. First of all, there was a case in the Leeds Crown Court, and we're going back to the late 1990s here. A man in his 60s was actually sentenced. Well, he faced a murder trial for killing his wife. Now, what happened was, he actually told the judge, he admitted it, and he openly said, "Your Honour, I've been nagged at for the last 25 to 30 years. I've had a horrible marriage, and nothing you can do can actually give me more punishment than what I've already faced at the hands of my evil wife." And this guy openly admitted it. It was a sentencing hearing, and the judge noted he was a good character and let him off on a suspended sentence. That case has been hidden left, right and centre, but I'm pretty damn certain that Penelope Jackson's lawyers are half decent. They'll be able to find it. The next case is the Queen on the application of Omela versus Waltham Forest in the Court of Appeal, 2004. Now, this was an employment case, but there is an analogy here. And just to show you how analogies work, let me demonstrate. A couple of years ago, I went to an employment tribunal. I was a litigant in person. I represented myself. I lost, and 4 lawyers told me not to appeal. I did appeal, and I won. The case was then sent for rehearing. At a rehearing, there was a directions hearing, and the judge said that the first tribunal's verdict must be shown to the second tribunal in order that they save time. My lawyer at the time argued that, first of all, that flew in the face of the Employment Appeal Tribunal's verdict, but secondly, he brought out a judgment in an educational tribunal verdict, educational appeal tribunal verdict, that said that in a remitted case, it is unlawful for the second tribunal to see the first tribunal's judgment. And we put that forward. We also had other case law and the like. And what actually happened was, the other side's lawyers from North Cheshire Hospitals actually said, that's an educational matter, this is employment. And the judge said, the field of law is irrelevant. The fact is that the principle has been established. So on that basis, we won a legal precedent. So the field of law is irrelevant. Now, in Omela, what happened, it was ruled that if there's a series of events, even if they're trivial, over a long period of time, if taken together, it justifies an employee resigning their post and claiming constructive dismissal. Now, there's an analogy here because this woman has suffered years of domestic abuse. Now, the thing here is, if she has years of domestic abuse, it could be online, maybe not, physical, emotional, neglect, sexual, all the other types of disguised before, then basically there is a high chance that a threshold has been reached where basically she felt she had no choice and something snapped and basically she stabbed him. That establishes the principle of law of what we call the last straw principle. Okay, now here's the thing. There was another case in the Court of Appeal which helps. It's a case of the Queen on the application of Kiranjit Ahluwalia versus the Ahluwalia case. Now, in Kiranjit Ahluwalia's case, this woman had a arranged marriage. She came over from India. She got married to a guy in London, and for years this guy abused her physically in every way you can imagine. And one night something snapped, and she poured petrol on him and lit him on fire, and he died as a result. And she faced life imprisonment. And in fact, she actually said that that when she was in prison, she felt free. Now, what actually happened was she got some lawyers who actually appealed her verdict, and they got it on one ground: diminished responsibility. Because she suffered years of abuse, she had a state of learned helplessness, which is, I'll come on to that in a minute. And because of a state of learned helplessness, there was a medical report which was overlooked that showed that she suffered endogenous depression at the time of the killing. It was very unclear why such an important report was not considered at the trial, and the Court of Appeal ordered a retrial. Now, this lady said she's of composed mind. I don't think that's the case. Nobody who suffers 25 years of domestic abuse is of composed mind. Something snapped. Basically, she's got a warped mind. She wasn't of composed mind, and there is an element of diminished responsibility. Now, in the Ahluwalia case, the Court of Appeal remitted the case to be reheard. However, the lower court, the Crown Court, couldn't excuse the fact that she poured petrol on him, and she was sentenced. It was commuted from murder to manslaughter, and she was sentenced to time already served. In this lady's case, she's already suffered a life sentence. She's had 25 years of hell at the behest of this horrible man. So my own view is that she should be allowed to be let off on a suspended sentence. I do not know who Penelope Jackson's lawyers are. As you can probably gather, I know what I'm on about. So what I'm asking you to do is to comment on this video and then share it among your friends in the hope that Penelope Jackson's lawyers see it and hopefully use the case law that I've given to basically get her off her a life sentence and hopefully a suspended sentence. Thank you very much for your time. I'll speak to you soon. Goodbye.